Continuing to help us all get our life plan in place is David L. Carrier. Good morning to you, sir.
Good morning, Leanne.
And this is all helpful information no matter what age you are. I know we always talk about the elderly, but this affects everybody.
It sure does.
So
that's right.
We always go off a couple questions that you've received from some people.
Right.
And we'll start with the first one. It says, my mother is in a nursing home, has a guardian over her financial affairs. Can she sign a labor deed on her house, leaving it to me? So in layman's terms, what does that mean?
Yeah, well, here's the problem. You know, the power of attorney is something that someone who's happy and healthy does to give authority to somebody else, right? So if you're, you do a healthcare power of attorney, so if I become incapacitated, now you can make healthcare decisions for me. Same way with finances, if it's done correctly, and it has to be very specific, right? But this is one of those, you know, 6 mistakes for the price of 1, because mom's already in the nursing home, right? The Ladybird deed is a way to avoid probate. It's a tool. Sometimes we use it, sometimes we don't, depends on the case. But the idea that you could get a power of attorney or a Ladybird deed when someone has a guardian, when someone's what we call a legally incapacitated person, well, it just doesn't work. You can't do that. Once you have someone who's guardian or conservator, what the court has decided is you're not able to make decisions for yourself, and until that is lifted, okay, you could be fine. I mean, you could be mentally competent, sharp as a tack, the whole 9 yards, but until you go to court and you get that lifted, you are legally incapacitated. You can't sign a deed. You can't sign a power of attorney. This is why it's such a big deal. You know, people are like, oh, well, I'll just go get a guardian. I'll just get a conservator. It's like, yikes. You're giving up total control when you do that. So that would be really the absolute last straw would be to go to the probate court, get the guardianship, conservatorship, because once you have it, you're out of control. And so you can't do what they're asking you to do. You can't sign the power of attorney. You can't sign the deed. Now, you could ask the court to sign the deed, and maybe they will in a given case. But again, you're leaving it up to the judge. You're saying, hey, judge, here's what I'd like to do. Would that be okay by you? The judge says, fine. Well, that's fine. But you're not in control anymore.
Gotcha. All right. Well, another one.
Yeah. Is
there any problem-free way to leave my homestead property to only one child in an estate plan?
Yes.
Only one child.
Well, that's what we have. We got our Smurfs here to help us out with that one.
That sounds like a big fight waiting to happen right there, right?
Well, you know, here's, you know, Papa Smurf wants to leave it to one of the kids. Which one? I don't know, maybe the suck up here with the president.
With the president, yeah.
Yeah, who knows?
Yeah.
You can leave it to one person. You know, when you, again, when you do a will, what's a will? Will is instructions to, you know, Justin the janitor here, right, to clean up your mess if you made one. Well, what if you don't make a mess? You see, if you're in probate court, now you've made a mess, we're cleaning it up, your will is instructions to the judge on how you want things done, to your personal representative. And then you've got all 3 kids hacking at each other, fighting over the thing. This is one of the reasons we're such a big fan of using the trust, because with trusts, you still have issues of undue influence and, you know, that kind of thing. Okay, there's possibilities there. But if you are competent, right, and you do decide, I want to leave it to this one or that one, you can have a very high degree of confidence that that's what's going to happen. Because we're not in court, we're not in the probate, there's no forum for these people to complain. Now, they can go to probate court, right, and they can say, well, mom was not mentally, or dad was not mentally competent, or she was twisting his arm, you know, but that's really what you're limited to. And it's very difficult when you have a trust, much more difficult than in probate, to make a pain out of yourself. Sure. You know, to create the nuisance. Yeah. And so, yeah, if you want to leave it to one of the kids, you know, is it problem-free? Probably. I mean, it is not at all unusual, not at all unusual for people to do just that. Okay. And so far, so good. I mean, with the trusts, no problem. With the probate, now you got to get them to waive and consent, and you know, it just opens the door that you don't have to open.
Okay, speaking of open doors, you have an open house.
An open house, that's right.
Is that a good transition
I like that
for you?
segue.
Is that tomorrow already,
You're a
right?
professional, aren't you?
You might have a future in this, yeah.
Yeah, that's tomorrow. That's tomorrow from noon to 5. And we've got there's ribbon cutting, and we've got snacks, and the caterer was over today, you know, saying, well, we'll put this table here and that table there.
To
okay,
feed
wonderful.
everybody.
Yeah.
Cool. All right.
And we've got goodies and the life plan workshops. That we, you know, just because we're doing an open house doesn't mean we're not doing life plan workshops. We've got another one coming up on Friday.
Okay.
So.
All right. Well, go ahead and give them a call with any of the questions you have, or shoot them an email too. There's all the information you need. DavidCarrierLaw.com, or a couple of numbers there on your screen. One toll free at 888-463-2843. Good luck at your open house tomorrow.
Looking forward to it. Thank you.